Welcome, legal eagles and environmental enthusiasts, to a deep dive into some of the most impactful, bizarre, and frankly, hilarious landmark cases in environmental law. Prepare yourselves, because the stories we're about to uncover are so wild, you'll question the very fabric of reality, and maybe the sanity of some of the judges involved. I'm talking about cases that redefined environmental protection, cases that made headlines, and cases that, well, made you wonder if the lawyers involved were actually arguing for the opposing side. Let's start with a classic, Sierra Club v. Morton. Now, this case on the surface seems straightforward enough. The Sierra Club, championing the preservation of the pristine mineral King Valley in California, sued the Department of the Interior over plans to develop a massive ski resort there. But the Supreme Court's decision was anything but straightforward. They dismissed the case, arguing the Sierra Club lacked standing because it hadn't demonstrated any specific injury to its members from the proposed development. I mean, come on. The very idea of a pristine valley being bulldozed into a ski resort isn't enough to grant standing. You might need a strong coffee after hearing that one. This ruling, however, spurred a significant shift in standing requirements for environmental cases, paving the way for future victories. The absurdity of the initial dismissal, however, remains a constant reminder of how the legal system can sometimes miss the forest for the trees, or, in this case, the entire valley. Next, we journey to the realm of the ridiculously specific, Massachusetts v. EPA**. This case saw Massachusetts, along with several other states, sue the Environmental Protection Agency for failing to regulate greenhouse gas emissions from automobiles. Now, while the subject matter is undeniably serious, the legal wrangling that ensued was, to put it mildly, a roller coaster. The Supreme Court, in a landmark decision, ruled that the EPA did have the authority to regulate greenhouse gases under the Clean Air Act. Imagine the sheer audacity of arguing that the EPA didn't have the power to regulate something directly contributing to climate change. It's like arguing that the fire department isn't responsible for putting out fires. Because, well, why bother? The sheer audacity of this argument, and the eventual, albeit overdue, victory, makes this case a truly unforgettable chapter in environmental law history. Now buckle up for a wild ride because we're about to discuss Friends of the Earth v. Laidlaw Environmental Services. This case involved Laidlaw, a company accused of exceeding mercury discharge limits into a South Carolina river. Friends of the Earth sued, alleging environmental harm. The company, in a move that only a lawyer could conceive, argued that because they had since upgraded their facilities and were now in compliance, the case was moot. Moot. As if the past environmental damage just magically disappeared. I wonder what planet the judge was on when they ruled in favor of Friends of the Earth, recognizing the enduring harm caused by past pollution. It's a testament to the enduring impact of environmental damage and the persistent fight for accountability. Consider the numerous lawsuits against oil companies for their contribution to climate change. These cases, while still unfolding, are monumental in their scope and ambition. We're talking about holding some of the world's most powerful corporations accountable for actions that have global consequences. It's a David and Goliath story on a planetary scale. The sheer audacity of these lawsuits, the sheer scale of the potential damages, and the sheer number of lawyers involved, it's enough to make your head spin. And let's not forget the defenses employed by the oil companies, defenses that range from the utterly unconvincing to the downright hilarious. We might just need a separate episode to cover all the twists and turns in these ongoing sagas. But the absurdity doesn't stop there. Remember the case against a farmer for his cow's methane emissions. Okay, maybe that one's a bit of a stretch, but the principle remains the same. The relentless pursuit of environmental justice, even in the face of the absurd, is a testament to human resilience and the growing recognition of the interconnectedness of our actions and their environmental consequences. The legal battles surrounding the construction of pipelines, the extraction of fossil fuels, and the protection of endangered species are all testaments to this ongoing struggle. We've seen cases involving endangered species, where the courts had to weigh the economic interests of development against the preservation of fragile ecosystems. We've seen cases where the very definition of harm in environmental law was debated at length, with lawyers sparring over the nuances of ecological damage. These aren't just dry legal discussions, they're battles fought over the very future of our planet. Think about the complexities of international environmental law, where nations grapple with transboundary pollution and the shared responsibility for global environmental problems. The legal frameworks are constantly evolving, attempting to keep pace with the ever-changing environmental challenges we face. And the cases, my friends, are often just as fascinating and complex as the problems they address. The stories we've touched upon today only scratch the surface. There are countless other landmark cases, each with its own unique twists, turns, and frankly ridiculous moments, that have shaped the landscape of environmental law. These cases are not just about legal precedents. They are about the fight for a cleaner, healthier planet, a fight that continues to this day, often waged in the most unexpected and sometimes absurd corners of the courtroom. So next time you hear about an environmental lawsuit, remember the stories we've shared today, the battles fought, and the victories, however small or improbable, that have been won. The fight for our planet's future is a long and winding road, and the legal battles are just one part of that journey. But they are a critical part, and a frequently hilarious one at that. Until next time, stay curious, stay engaged, and stay tuned for more legal adventures in the wild world of environmental law.